Esteemed guests, colleagues, students, friends, family, welcome to UCL Faculty of Laws. I'm Eloise Scotford, and it is my absolute pleasure as Dean of the Faculty to welcome you to this evening's inaugural lecture. The professorial inaugural lecture is a rite of passage that we take very seriously at UCL. It's an opportunity for a new, well, not quite new, but for tonight's purposes, you're a new professor, Martins. A new professor to inform a wider audience about their field of expertise and their programme of research. It's also a moment to recognise and to celebrate the very significant achievement of promotion to Professor of Law. That moment of celebration is a particular emphasis in tonight's proceedings, as you'll see, with certain moments of wow as the night goes on. As academics, we are usually in the business of critique and challenge. This evening, however, is a chance to stop and to celebrate what we work so hard to achieve in academic life. That also means there'll be no questions at the end of the lecture, no challenge, but maybe over drinks. Over his career to date, Professor Paparinskis has built a very strong foundation as a respected expert in public international law. He's a member of and active participant in many notable international law bodies, and this evening's chair will tell you more about that. He sits on the editorial boards of many prestigious international law journals and has an extensive list of publications. As an environmental lawyer, I'm delighted that Martin's got my memo that all lawyers are environmental lawyers. He has significant expertise in international water law, being a member of the UNICE Water Convention's Implementation Committee, and in December he argued the case for Latvia in the oral phase of the advisory proceedings on obligations of states in respect of climate change, one of the many big ICJ moments of 2024. In the faculty, Martins has also made a significant contribution. He has been at UCL for almost 12 years, since his appointment as lecturer in 2013, coming from Oxford, where he did his MJur, DPhil, and held a JRF post. Since his arrival at UCL, he has been one of our leading lights in public international law, very strong crowd, I have to say, teaching students in general public international law, foreign investment law, international arbitration, international environmental law, and the law and policy of courts and tribunals. I have some personal happy memories of Martins at work. One, watching him drag his large, heavy suitcases of books into his new office in the new part of the building. There is no one taking away that WC1 real estate from Professor Paparinskis. Attending conferences across Europe where Martin's name comes up with notable regularity. Do you know Professor Martins Paparinskis? I do. I said I do. I do know him. I get asked this question. I often get asked that about many of my esteemed colleagues, but it does come up a lot, I have to say, Martins. And last week, his idea of bringing a guest speaker to class was to bring along the ambassador of Chile to discuss South American water disputes. Lucky students, as you do. So that high-level international law engagement might relate to one fun fact about Martins. He speaks 6 languages, I think, by my count. 5 fluently, 1, I think, is the... Anyway, we can test you over drinks for anyone who has good European language skills. Perhaps that is his secret weapon in international law diplomacy. So the faculty is absolutely delighted this evening to celebrate all of Martin's considerable achievements. It's now my pleasure to introduce this evening's chair, Professor Vaughan Lowe, KC. Professor Lowe is a practicing barrister at Essex Court Chambers, mainly in the field of international law, having argued cases in the ICJ, the ECJ, ECHR, ITLOS, the Iran-US Claims Tribunal, ad hoc arbitral tribunals and courts in England and Hong Kong, amongst others. He's Emeritus Chile Professor of Public International Law and Emeritus Fellow of All Souls College at the University of Oxford. Professor Lowe has acted as an arbitrator in many investment arbitrations and on boundary dispute tribunals. He has served as an ad hoc judge of the European Court of Human Rights and as UK-nominated judge on the European Nuclear Energy Tribunal. Professor Lowe advises extensively on international law matters and has been called by Legal 500 the superstar in the public international law field, peerless in a class of his own. At that, I will hand over to this evening's chair.
I think it was Gore Vidal who said that every time I hear of a success of one of my friends, a little part of me dies. But this evening is a genuine delight, and I mean that with complete sincerity. And I've known Martins for over 20 years, since he first went to Oxford, and they have been wonderful and enriching years for me. When he arrived there were three characteristics that struck us all, I think. First was his extraordinary and encyclopedic knowledge of international law, of case law, treaties. The second was the precision and, more rarely, the subtlety of his analysis of legal problems, which he would demonstrate at the wonderful seminars we had there. And the third was a sense of humour that is so dry that it's making its own contribution to climate change. These are interesting days for international lawyers. The difficulties facing international law are obvious. Less obvious is the opportunities that faces international law. I have never known and cannot think of any time in the last 150 years when the gathering of talent amongst international law scholars has been so intense and of such a high quality. That's true around the world, and for some reason it's particularly true in the United Kingdom, upon which international lawyers seem to converge from many other countries. And Martins is right at the heart of it. And he has now a chair at one of the great world centres for international law, and his seat on the International Law Commission, which is as close to the beating heart of international law as I think it's possible for the international system to generate. Over the last 5 years or so, he's focused particularly on questions of compensation, taking the lead from, I think, an observation of Dinah Shelton's that remedies serve social as well as individual needs. If you award someone huge sums in damages, it has implications not only for the recipient and not only for the person who has to pay the recipient, but also for everyone else who's living within the system where that kind of enforcement prevails. The lawyers, the international lawyers here, will probably know Martin's work best from his 2020 MLR paper and the great symposium that the MLR organised on his paper on crippling compensation in 2021. And more recently, the 2024 paper, which he prepared for the International Law Commission, which got this question of compensation onto the International Law Commission's agenda. In doing it, he's doing a typical Martins thing. And he's taking something which seems perfectly clear, perfectly well established, so well established that it's part of the litany of international law in all pleadings before tribunals, that whenever a state is injured by a breach of international law, there has to be full reparation made for it, the so-called Chortsov-Factory formula. But instead of simply taking that as the kind of shibboleth that it is, Martins is looking at the problem and asking why. Why is it that we assume that there should be full compensation for any damage that is suffered? And because remedies are not only a bilateral matter between the payer and the payee, they also have a wider social connotation. What should the position be if a state has an award of $5 or $6 billion made against it, and the state's economy simply cannot sustain that payment without making real, immediate and hurtful cuts to its public spending in its own country? Is the answer the same regardless of the breach of international law that has been committed? And these are the kind of questions where it is the subtlety of his analysis that he's bringing to bear that I think makes us all look forward with great interest and great enthusiasm to what the ILC produces on this. And through this, again in typical Martins fashion, it seems to me that you're actually asking basic questions about the whole of international law. What is the role of law in this context? What is the role of a court in awarding damages against one person and to another. Is this the role that it should be playing? Is it the role that it could be playing, or should we be doing something else within the system? Well, I know we're going to hear some of this tonight, Martins. We've heard quite enough of me, so I shall hand over to you and say again what a delight and a privilege it is to be here at your inaugural.
I'm very grateful to Dean Scotford and Professor Lowe for the introductory, very kind, exceedingly kind observations. The development of public international law presents one of the classic puzzles of the discipline. A sometime professor of international law at UCL began his Hague Academy course by asking the audience to imagine an island inhabited by about 200 families, not all equally fortunate, that need rules but do not have an institutionalized legislature. We do know, as confirmed by the International Court of Justice oral proceedings last December and obligations of states in respect of climate change that Dean Scotford mentioned, the high degree of sophistication that societies in small islands bring to legal arrangements, domestically as well as internationally. But as a metaphor for the international society, and the challenges for the international legal order, the island seems to me to capture very well the puzzle of how rules can be made and changed in a deeply pluralist and decentralized environment, particularly in the world that seems ever more divided on questions of universal nature. And I believe that I do not need to belabor the point before an audience of predominantly international lawyers speaking in late February 2025, when in every week decades of international law have happened. Can development of rules work in such a society at all, and how? To make the question less abstract, consider the following three examples that I have reflected upon for some time. First, a key question in the pending obligations of states case, particularly in light of withdrawal of certain states from the climate change treaty regime. Is the principle of prevention of significant harm to the environment applicable to anthropogenic greenhouse gas emissions? By way of example, United Kingdom argued no, or as a fallback that content of customary international law did not exceed obligations in the Paris Agreement, while others, such as Belize, took the opposite position on both points. Secondly, crippling compensation that Professor Lowe alluded to. Does the principle of full reparation for internationally wrongful acts, including by compensation, take into account the financial capacity of the responsible state? The ILC said no in the 2001 articles on responsibility of states for internationally wrongful acts, while the International Court of Justice in 2022 left the question open in armed activities on the territory of the Congo. Thirdly, does immunity ratione materiae from the exercise of foreign criminal jurisdiction apply in respect of crimes under international law? The ILC said no in the draft articles on immunity of states from foreign criminal jurisdiction adopted on first reading in 2022, having determined by a vote in 2017 a discernible trend towards limiting the applicability of immunity, with which some members disagreed. Comments by states for the second reading, submitted in late 2023 and 2024, reflect a degree of difference of perspective on this matter, illustrated by comparing the last comments by Germany and Israel. These examples have significant practical implications and also raise hard questions about the nature of international law and its determination and development in circumstances of strong disagreement between the relevant actors and institutions. The development of international law is a broad topic, mostly addressed by narrowing its scope, whether to focus at a particular field, as the president of the ICJ occasionally does in their yearly remarks to the Sixth Committee of the General Assembly, or an institution, as in Hirsch-Lauterpacht's development of international law by the International Court. Similarly, I have picked the substantive case study of development of international law of compensation with an institutional eye to the inclusion in the long-term program of work of the ILC in 2024 of the topic compensation for the damage caused by internationally wrongful acts. The Professor Lowe stole my punchline. I have the declared self-interest of being the person who proposed this topic. At the same time, to borrow from the style of the chapter titles of 19th century romantic adventure novels, by identifying the parameters for development regarding this particular topic, I hope to incidentally explain the modern international law system more generally. The focus on the Commission is not entirely arbitrary. The international society does not have an institutionalized legislature, but it does have institutions, also at the universal level, in various ways relevant for development of international law. After attempts to give the General Assembly power to establish the content of international law with binding effect were rejected in San Francisco, the Assembly was nevertheless entrusted with the task of encouraging the progressive development of international law and its codification, which in due course led to the creation of the ILC. It is thus not surprising that development of international law is often addressed either as part of the discussion of the Commission's work or by using its contribution as test cases for testing hypotheses for how international law works. In my lecture, I will address 3 points. First, in line what appears to me to be the established practice of inaugural lectures of public international law, a brief academic Bildungsroman. Secondly, explain the variety of considerations that shape the development of international law, with an eye to clarity and coherence, drawing upon examples from my own international research and work. And thirdly and finally, reflect on whether compensation is an appropriate topic for development of international law in the 2020s. I build on insights articulated by the chair of tonight in a series of articles some 20 years ago, about the time that I came to Oxford to study international law with him, which emphasized clarity and coherence. Clarity about the current law and the claim for change, and coherence of the claim with existing law, both substantively and in relation to institutions and procedures. These considerations are key in light of the possible path of development of infinitely varied international law through her institutions, and of particular importance if but of course assumptions about international law are themselves subject to pressures of development. I will not say much about recent developments. Such remarks have the tendency to age quickly and badly. I will speak more generally about change, and I will say that everything in a legal order may change, despite longevity of rules and institutions, regularity and routineness of their invocation, and even possible deployment of foreign or dead languages in their designation. Resistance to undesirable legal change is to be taken seriously by participants in the legal order, because law will not do the work for them. While a calm and vinous optimism possesses our banquet, outside the owls hunt maternal rodents and their furry brood, if I may be permitted a slightly cryptic quote. I turn now to my first theme, the customary nod to journey that has brought the speaker to Dennis Holland Lecture Theatre. My academic journey is simple. I'm very grateful to UCL Laws, the first and, one expects, possibly the last institution to give me a permanent contract, although I did enjoy my earlier, more fleeting presence at Merton College, Oxford, and NYU. And I'm also an Eastern European international lawyer, also in the eyes of the General Assembly, which elected me to the ILC from the Eastern European group of states. In preparing for this lecture, I flicked through Marty Koskiniemi's piece on the world 75 years after Lauterpacht's Function of Law in the International Community, published in a 2008 British Yearbook of International Law, volume close to my heart because it contains my own article. But moving onwards, Koskiniemi suggests there, among other things, that Flick could only have been written from the inside of the German public law tradition in which Lauterpacht had been brought up, from a vivid sense of the urgency of the legal system's ultimate foundations. It leads me to reflect on how my own approach to international law is informed by legal upbringing. I start with a degree of caution. I am a generalist international lawyer and tend to think that a sound doctrinal answer to a question about international law, particularly of universal character, necessarily includes engagement with different materials and approaches. from the various legal systems and regions of the world, having due regard to inter alia, gender and linguistic diversity, to use a language from the Commission's recent draft conclusions on subsidiary means for the determination of rules of international law, under the guidance of Special Rapporteur Charles Jallow. The perspective of particular states, united by regional, numerical, directional, or other characteristics, constitutes and enriches the process of determination and calibration of universal consensus as part of the general conversation, not limited to the initial actors or catalysts for either exclusivity of articulation of perspectives or their evaluation. By way of example, in the obligations of states, the judgment of the European Court of Human Rights in Verein Klima Seniorin in Schweiz and Switzerland was invoked by participants from different regions and legal settings, including parties to other or no regional human rights instruments, as on the very first day of all proceedings, Vanuatu, Albania, Germany, Antigua and Barbuda, and Australia, reflecting the French alphabetic order, hence Germany. This is an international law argument as it should be. And of course, the particularly affected actors may choose not to engage. Switzerland did not mention the case. In sum, if sound generalist doctrine is already shaped by all the particularist wrinkles, one wonders about the doctrinal value of casting a second particularist gaze. Still, the legal history of Eastern Europe may offer certain insights about the nature of law and the international legal process, present but more obscured in other settings, which I will introduce by reference to two examples. The first reference is to the name that may be less familiar to some of you, Peter Stučka, an influential figure in the Latvian social democratic movement since the late 19th century, whose work was described by Hans Kelsen as the first important attempt to develop a specifically Soviet theory of law. It is easier to say what Stučka was not in the early Soviet Russia. Among many other posts, he was the first People's Commissar for Justice, the first Chief Justice of the Supreme Court, the editor-in-chief of the first Soviet Encyclopedia of State and Law, and the first director of the Institute of Soviet Law, not to mention briefer stints such as the head of the government of Soviet Latvia in 1918-20. He also drafted the 1917 First Decree on Courts, which abolished all the pre-existing courts, replacing them by revolutionary tribunals, as well as those pre-existing laws contrary to revolutionary consciousness. Speaking in Bentham House, I know that in a contemporary article, Stučka referred to Bentham in support of his hope for simplified and accessible future codifications. Kelsen was right to describe Stučka as not a specialist in international law, but he was the rare writer to define law so as to fit both domestic and international spheres, unlike the occasional domestic focus that leaves international law for an awkward special case or a postscript in the last chapter or article, known even at UCL, albeit before my time. The second example, more firmly located in the realm of international law, relates to the statehood journey of the Republic of Latvia, unreservedly recognized by Soviet Russia in the 1920 peace treaty after the collapse of the Stučka-run Soviet Latvia, under, I quote, the right of self-determination for all nations, even to the point of total separation from states with which they have been incorporated, and in view of the desire expressed by the Latvian people to possess an independent national existence. 20 years later, the sentiment had somewhat run out, but to quote from Latvia's oral submission obligations of states, despite Latvia's occupation and annexation by the Soviet Union in circumstances involving the use of force and duress in 1940, the underlying illegality and the sparsity of its express recognition on the part of third states could not dispraise the continuity of statehood, a proposition generally accepted upon Latvia's factual recovery of independence, forcibly suppressed more than half a century earlier. End of quote. The story of how collective non-recognition buttressed the juridical bridge of Baltic statehood over the span of half a century until the facts on the ground caught up is well known to international lawyers. I introduce it here to consider the reaction of the post-World War II international institutions, particularly those engaged in development of international law, to the absence of a state member of the previous universal organization due to annexation indeed a member that was president of the League's Council during the discussion of annexation of Ethiopia in 1938. I will consider in turn the ICJ and the ILC. The ICJ during the Cold War dealt with many foundational cases on self-determination, territory, and use of force. None of them mention Latvia. Two disputes, though, on more technical issues in the 1950s occasioned passing remarks. In the fisheries case in 1951, where the permissibility of straight baselines was at issue, Norway invoked Latvian rules of neutrality of 1930s as throwing light on the meaning of international waters, to which Sir Eric Beckett on behalf of the UK objected, among other things because Latvia was no longer independent. In aerial incident of 27 July 1955, Israel and Bulgaria disputed the meaning of Article 36, paragraph 5 of the Statute of the Court, regarding the possibility of relying on declarations recognizing as compulsory the jurisdiction of the Permanent Court of International Justice, and also addressed the 1935 Declaration of Latvia. Pierre Cotta, on behalf of Bulgaria, observed in my translation that Latvia had sunk in the turmoil of war and disappeared as a state. And while Shabtai Rosen, on behalf of Israel, disagreed regarding the implications for the case, he similarly noted that it would be fair to say that in 1945 there was room for doubt, to put it at its lowest, as to the position of Latvia after the restoration of peace. The court did not mention the argument at all. While the joint dissenting opinion of Judges Lauterpacht, Wellington Koo, and Percy Spender noted that for the drafters of the court statute, I quote, in all the circumstances of which the court must take judicial notice, the position of Latvia created no problem. I note without comment that the contemporary Oppenheims, edited by Lauterpacht, footnote Baltic states the paragraph praising non-recognition as a supplementary weapon of considerable legal and moral potency in the absence of a regularly functioning machinery for enforcing international law. I now turn to the ILC. The Commission was entirely comfortable discussing Latvian practice from the 1920s and 30s, including in the work on the draft code of offences against the peace and security of mankind, the most favoured nation treatment clauses, succession of states and state responsibility. And indeed, the 1920 peace treaty I quoted before was mentioned several times in the text of the commentary to the 1981 draft articles on succession of states in respect of matters other than treaties, as an illustration of practice regarding succession to currency and libraries. The Commission was, however, more circumspect regarding the character and consequences of the events of 1940. The Special Rapporteur on the project culminating in the 1981 draft articles spoke of uniting of the Soviet Union and the Baltic states, where the initial non-recognition was normalized later, framing notable in light of his familiarity with the 1920 peace treaty and overall strong emphasis on self-determination in the Commission and elsewhere in his truly illustrious career to follow. Summary records of the Commission, as I now know, are a form of art. But in the first 2,252 meetings from the start of its work until Latvia became a member of the UN in 1991, the possible unlawfulness of the events of 1940 appears to have been mentioned once in an exchange between George Sell and Yepes in the afternoon session of 4th of June 1951. Now you may well think that this is not an unusual story. International law, probably more so than any other type of law, reflects the society, ubi societas, ibi jus, in all relevant respects, including the composition, interests, and values of the particular time. International lawyers, both the doctrinal ones and particularly those partial to theoretical and historical perspectives, are very familiar with inequalities and omissions in the international legal process, even when engaged through institutions or arguments purportedly universal in character. Still, the discussion does illustrate certain points, probably less contrarian today than when I started drafting the lecture. First, everything in a legal order can change, everything regarding rules and institutions in a technically straightforward manner. Recall the 8 paragraphs and 646 words of the first decree on courts, existing institutions out, revolutionary consciousness in. Secondly, everything can change even when rules at issue appear necessarily implicit, almost tautological, as the very first session of the ILC suggested was the case for the state's right to exist and preserve its existence. Thirdly, everything can change even within universal institutions, working through universal rules. It took only 8 years for Latvia to go from chairing the Council of the League of Nations to playing no role in the United Nations, and savvy procedural tweaks, such as delineating Chapter 11 of the Charter in the United Nations General Assembly Resolution 1541-15 as prima facie applicable solely in respect of a territory which is geographically separate, enabled articulation and powerful implementation of the right of self-determination through the UN without occasioning but the rare awkward judicial shrug in the Baltic direction. Political disagreement in these matters was underpinned by juridical consensus. Notably, when the UK representative spoke of Baltic states as the world's 3 newest colonies forcibly incorporated in the Soviet Union during the 1960 General Assembly discussion of the draft declaration on the granting of independence to colonial countries and peoples, it was to show that rhetorically much better ammunition would be deployed if Soviets continued to criticize British policies, rather than argue for Baltic legal treatment in this setting. There is little in which we in the UN can do to help these people under Soviet control, the minister said. Fourthly, and here I repeat the point that I to some extent foreshadowed, the legal order will not do the work for its participants, even for rules that are long-standing and routinely repeated, have jus cogens character, or are intrinsic to the legal order, if they are challenged and not defended by the relevant actors. International legal order is currently structured around the interaction of sovereign, equal, and independent, close to 200 polities, as well as international organizations. But that is not the only way how legal order can be organized, and indeed for most of its existence it has not been, which is different from saying that international law and international lawyers would be unimportant in a differently organized world. I note von Lowe's cautionary question a decade ago of whether rules may be developing on spheres of influence that would significantly qualify the principles of sovereign equality and independence of states. I now turn to my second larger theme, factors calibrating the development of international law. As foreshadowed, I will address the topic in 2 parts, dealing in turn with the clarity of the claim and the coherence of the claim with international law. I will make 5 points about the clarity of claims. I will first introduce the concept, and then address the vocabulary through which the claim is articulated, the ambiguities in the vocabulary itself, and the distinctions between the claim about rules and their application, and the claims of doctrinal and normative character. First, it is important to be clear what the legal claim is. The ILC Working Group on Sea Level Rise in relation to international law, under co-chairpersonship of Patricia Galval-Teles, Juan José de Santolaria, and Ilfer Oral, addressed last year the question of continuity of statehood in circumstances where the land surface becomes totally or partially submerged or rendered uninhabitable by rising sea levels. The summary of the closed discussion notes the call by some members for, I quote, the need to carefully identify the precise rationale for statements by states, without reading into them views that states had potentially consciously chosen not to put forward. Those states that supported the continuity of statehood could have made claims of several kinds, including first, that there existed an established positive international law rule on the point, secondly, that there could be flexibility in the application of a vague but still positive rule to address the point, thirdly, that there existed reasons why developing international law in a certain direction would go with the grain of the system, particularly when arguments are made by analogy, and fourthly, that they were taking no position on the existence or desirability of positive rules at all, and were simply indicating a policy preference. Note that the precise rationale of the claim may well mean lack of any legal claim at all. Clarity stands here for accuracy with which the position is articulated, rather than substantive concreteness. And by way of example, the United States in the 6th Committee stated that, I quote, its policy that sea level rise driven by human-induced climate change should not cause any country to lose its statehood or its membership in the United Nations, end of quote. Conversely, Latvia made a clear and concrete claim in obligations of states that as a matter of positive international law, existing statehood is not affected by climate change-related sea level rise, because factual control over territory is not always a necessary criterion for the continued juridical existence of states. Evaluation of clarity of the claim depends on who and where makes it. Institutional context matters. Recall Lauterpact, the scholar and judge, and the judge. For the ILC, position by the Commission itself is adopted, articulated, and evaluated very differently from that of the Special Rapporteur, the chair of the drafting committee, a member introducing a possible new topic, or a member full stop. And success may vary in different roles. I praise Georges Sell as a member, but as a Special Rapporteur on arbitral procedure, his draft remains the only ILC output the Sixth Committee has sent back, because it went beyond what the majority of governments would be prepared to accept. Yet further granularity is provided by benchmarks such as codification, progressive development, desirable practice, as well as what the Commission called a discernible trend, and some members a quote-unquote trend. The meaning of the benchmarks themselves may change, as recently shown by Christiane Alborn regarding progressive development, originally understood not as lex ferenda customary international law, but to quote the Commission's statute, as the preparation of draft conventions on subjects which have not yet been regulated by international law or in regard to which law has not yet been sufficiently developed in the practice of states. Secondly, the legal claim is articulated through the shared generalist vocabulary on sources and actors of international law. In the ILC discussions, I don't know whether to my surprise or not, I have mostly inclined towards a methodologically more traditional end of the spectrum of views expressed, considering rules and actors and sources reflected in Article 38.1 of the Court statute as broadly satisfactory. In my view, there is little legally relevant that would not be capable of explanation in these terms, provided that we approach the sources flexibly enough to take into account the material reality of modern international relations, including what the ILC calls the rules of the international organizations, as well as the important distinction made last year by the Special Rapporteur on non-legally binding agreements, Matthias Forteau, between the effects produced by certain materials themselves and the effects that other rules make these materials produce. Even the Commission's rare textual change of the text of the statute of the Court in the 2023 draft conclusions on general principles of law, replacing civilized nations with community of nations, in my view justified, even though I was not a member of the Commission when the change was made, is explained in the commentary as not intended to modify the scope or content of Article 38, paragraph 1c of the statute. And oddball assertions in state practice and judicial decisions may simply be reflective of manifestly bad legal reasoning, to be challenged through the legal process or available institutions. By a successful example, investment law, through exit-annulment committees in Vivendi, Universal, and others against Argentina, and Venezuela Holdings, BV, and others, and Venezuela. My third point, in slight tension with what I just said, is that not all dragons have been slain, in the sense that hard questions regarding foundational questions still remain. By way of example of lively discussions in this quinquennium of this Commission, I note the important upcoming second reading on general principles of law with Special Rapporteur Vasquez Bermudez, which will engage with general principles of law formed within the international legal system. The topic on subsidiary means, where the Commission suggested the existence of subsidiary means beyond those enumerated in Article 38, paragraph 1d of the statute, and the definition of international organizations in draft guidelines on settlement of disputes to which international organizations are parties, with Special Rapporteur Reinisch, textually different from the 2011 articles on responsibility of international organizations. And of course, not everybody will be persuaded by answers to the hard questions. As an external observer, I found it not entirely easy to follow the Commission's reasoning for why subsequent practice was a relevant material of interpretation, not only under Article 31.3b of the Vienna Convention on Law of Treaties, but also Article 32. Although the ICJ in 2020 immunities and criminal proceedings judgment and all judges but one writing separately appeared similarly unpersuaded, so I may be puzzled in good company. Fourthly, the distinction between determination of rules and their application. I began this talk by asking whether the principle of prevention of significant harm to the environment, usually invoked in disputes between neighboring states such as pulp mills on the river Uruguay, also applies globally to anthropogenic greenhouse gas emissions. Disagreement on the answer seems to me to partly relate to whether territorial contiguity is characterized as an element of the content of the rule or merely happenstance of its application, which dictates in turn whether practice and opinio iuris expressed in non-contiguous settings need to be demonstrated. It is not surprising, in my view, that distinction between determination and application is not straightforward. International law of sources, as well as responsibility, takes an agnostic attitude regarding the nature of institutions, if any, in which rules are applied. The situation is not helped by the apparently inconsistent way in which the VCLT uses the term application to indicate both bindingness of a treaty or a part of a treaty in particular circumstances for provisional application and application of successive treaties, and factual application for the role of subsequent practice and agreement on interpretation. Whether states and tribunals have themselves created a clearer grasp on distinction is also uncertain. Practice relating to intervention under Article 63 of the ICJ statute, textually limited to issues of construction and thus by implication excluding application, may seem to some not entirely consistent regarding the location of the line between these categories. I appeared myself before the court on behalf of one of the intervening states, so I will only note the observations by Vice President Gevorgian and Judge Shui in allegations of genocide case regarding arguments that in their view went beyond construction, although the vagueness of the relevant primary obligations calling for assessment in concreto make that boundary particularly porous. Investment law faces this challenge in arbitral decisions about fair and equitable treatment, where legitimate expectations, something of a leitmotif in the case law on the fair and equitable treatment standard, is not entirely easy to explain either in terms of principles of treaty interpretation or under general principles of law. The Eurus Energy Holdings Corporation and Spain Tribunal, chaired by James Crawford, suggested that, therefore, legitimate expectations may be better viewed as essentially consideranda, relevant factors to be taken into account in interpretation and application. The fifth point relates to the distinction between doctrine and normative claims. The commentary to the 2018 conclusions on identification of customary international law notes somewhat dryly that writers not always distinguish or distinguish clearly between law as it is and the law as they would like it to be, end of quote. The point is not unfair, but the distinction is not an easy one to draw either. Rhetorical styles differ between languages and disciplines, both types of claims are richly varied, and sophisticated doctrine is sensitive to normative debates, just as effective normative critique must engage doctrine. Nevertheless, a transparent pursuit of the distinction is important in scholarship as well as the Commission. Recall, the hard question whether immunity ratione materia applies in respect of crimes under international law, which the Commission will address in the second reading of Draft Article 7 of the 2022 Draft Articles. I will not speak of my own position, while the second report of the Special Rapporteur Claudio Grossman is not public, but will note the discussion in the commentary to Draft Article 7, where in paragraphs 10 and 12, the Commission and some members explain their position for and against the provision respectively. Those following the debate will appreciate the subtlety and nuance of the debate. But in my view, the disagreement turns at least partly on whether certain broader systemic considerations are characterized as relevant for doctrinal determination of rules or solely for normative change and critique. I am sympathetic to calls for the ILC to communicate to its audience whether particular claims are predominantly about progressive development or codification, even if sometimes both elements may be intertwined. Paragraph 12 of the general commentary to the 2022 draft articles, referred to repeatedly by Special Rapporteur Grossman, promises to provide states with enough information in this regard and ensure the transparency that must govern the work of the Commission. I agree. I am less persuaded, however, by suggestions by some that explicit language coding is the only way to communicate the distinction, which is also, in my view, identifiable by examining the type of reasoning employed, as the ICJ did with little trouble in the case concerning dispute over the status and use of the waters of the Silala, which, as Dean noted, we just discussed with our students a couple of weeks ago. I now turn to coherence of these claims with international law, and for consistency's purpose, again, we'll make 5 points. I will consider what it means for claims to go with the grain of international law, then address pertinent characteristics of the international legal order and particularly note the repeat character of states, introduce the concept of relative shallowness of systemic assumptions, and the institutional variety with which claims must cohere. Recall the typology of possible claims, including the claim for why developing international law in a certain direction would go with the grain of the legal system, as well as Latvia's submission to the ICJ that existing statehood is not affected by climate change-related sea level rise. Latvia's agent went on to say that Latvia's conviction about continuing statehood in these circumstances is reinforced by the legal principle underpinning Latvia's experience of continuing statehood since foundation in 1918. This, in my view, is an example of an argument that goes with the grain of international law, by showing that a particular claim is consistent with how relevantly comparable questions have been dealt with elsewhere. Another example is a suggestion by the Eurus and Spain Tribunal I quoted from before to conceptualize legitimate expectations as a circumstance of application of inequitable treatment. That would go with the grain of how rules drafted by reference to equity are approached in other, may I say, more developed fields, such as equitable and reasonable utilization in transboundary water law, or delimitation of the continental shelf in law of the sea. And comparison may reveal that circumstances are not similar and therefore should be held differently, as the Commission did last year in its work on immunity of state officials, by merging draft Articles 5 and 6 so as not to have symmetrical structures for parts 2 and 3 and to emphasize the differences between immunity ratione personae and ratione materiae. And there may be reasonable disagreement over what goes with the grain. In the same topic, I argued for a definition of an act performed in official capacity that would align law of immunity with rules on attribution in Articles 4 to 7 of the 2001 articles. The drafting committee took a different view on the matter. My second point relates to the nature of international law. Unlike domestic law, but the decentralized international society makes it less easily capable of succinct description in positive terms. I have found helpful the perspective of tensions between concepts that are distinct, indeed sometimes opposite, and simultaneously express the important truth about the nature of international law. The relevant tensions between general and special, universal and regional, and formal and informal may combine in different ways in relation to a particular issue in a particular setting, as demonstrated in obligations of states' pleadings. And I referred already to the Commission's statement in its work on subsidiary means that due regard should be had to gender and linguistic diversity, explained in the commentary as non-exhaustive, and in addition to racial diversity, capable of including ethnic, cultural, and religious diversity, as well as sexual orientation, end of quote. In sum, a sound doctrinal claim will engage and cohere with all the relevant perspectives. My third point relates to the repeat character of states and at least some international organizations as actors in the international legal process. The formalized dispute settlement framing of current issues may sometimes obscure that states have interests beyond winning the particular case, whatever winning would stand for in the circumstances, whether it relates to dispute settlement in the same or other international courts or tribunals or international relations outside the courtroom. Consistency is important, both in the technical sense of calibrating the weight of the legal claim and the avoidance of embarrassment of being caught flip-flopping, and in the written version, being caught is in brackets. It may well be the case that participants in obligations of states reviewed submissions for consistency with positions taken elsewhere, including before regional and universal human rights bodies, in the climate change treaty regime, and pursuant to the principle of sincere cooperation as applicable. And sometimes the temporal scope of consistency is very wide indeed. When Latvia recognized the jurisdiction of the ICJ as compulsory in 2019, it noted, Pass Outer Pact in 1951, that this declaration replaces the declaration made on behalf of the Latvian government in 1935. This brings me to my fourth, somewhat contrarian observation, that systemic assumptions may sometimes be shallow, in the sense that a limited number of events significantly change how the broader balance is perceived. Now, judicial decisions will provide the more obvious examples. Think how differently the balance between bilateral and multilateral interests would be perceived in the court if it had struck out two claims based on legal interests of states other than an injured state, really just two cases. But the point applies more generally. For the last 20 years, one standard story about the ILC contrasted the golden era of the Commission, when draft articles led to the great codification conventions, with a lukewarm reception by the Sixth Committee more recently. And many of you will know the line that former legal counsel of the UN had in that regard. Now, you may know that the General Assembly in December decided to elaborate and conclude a legally binding instrument on the protection of persons in the event of disasters and convene the United Nations Conference of Plenipotentiaries on Prevention and Punishment of Crimes Against Humanity, both on the basis of ILC drafts, and the latter the first ILC draft-based conference since the Rome Diplomatic Conference establishing the International Criminal Court. Now, I'm not suggesting that the standard story about the ILC should be reversed, but call for a degree of caution and humility in discussing systemic balance when the relevant assumptions are, in this sense, shallow. My fifth point relates to institutional variety. A saying many moons ago in Oxford went that a generalist international lawyer should know something about everything and everything about something, which rhymes and is true, and I would only add that they should preferably know everything about at least two different kinds of something, not to become too accustomed to particularities of a single specialized field, which for me would be investment and transboundary water law, very different indeed in institutional terms. Investment law, in one sentence, is a lightly institutionalized field, where key questions are framed by and by reference to ad hoc investor-state international arbitration decisions, with reactions by states mostly dispersed through variously limited means of review mechanisms, engagement with the underlying instruments, and compartmentalized multilateral institutions. Water law is state-driven, often through standing institutional bodies or meetings of parties to instruments, with reasonable disagreement about the value of formalized dispute settlement. In short, development of international law will surely take different routes through and around the institutions in the specialist fields. I now turn to the second half of the title, the case for revisiting compensation. I invite you to form your own views about the merits of my proposal on the basis of syllabus provided in Annex 1 to the last report and the state's comments in the Sixth Committee, or helpfully available on the relevant websites, and will reflect instead on 5 more general questions. First, is the issue important? The syllabus notes that compensation is addressed in a rich body of recent decisions by interstate courts and tribunals, as well as bodies considering claims brought by individuals and other non-state entities, as well as in organizational practice. The International Court, by way of example, has in recent years dealt with compensation in 3 contentious cases relating to human rights, environmental issues, use of force, humanitarian law, and macroeconomic damage, in the advisory opinion on occupied Palestinian territories, and may well consider a compensation for economic injury in certain Iranian assets in due course. Hard legal and policy questions are also raised elsewhere. The ConocoPhillips, Petro-Tsuata BV, and others, and Venezuela. An Allman committee recently noted in deciding not to set aside a multi-billion largest ever ICSID award that striking the balance between the best incentive to induce the state's compliance with the treaty and crossing the line of impermissible punishment for exercising sovereignty over natural resources with the risk of the investors' overcompensation is the challenge of any reparation model. And one appreciates that the $8 billion turning on this challenge sharpens the mind somewhat of factors involved. Secondly, why revisiting? The syllabus notes that the Commission addressed rules on compensation in its 2001 articles, recognized to be reflective of customary international law, expressed in Article 36 on compensation, and other provisions related to reparation more generally. The proposal builds upon the conceptual framework and analytical distinctions of the 2001 articles, as well as their substance, without any direct or implied criticism, noting that the drafting of Article 36 was prudent in light of the available materials, and the provision has to be read alongside its very thorough commentary. Thirdly, what would revisiting compensation entail? Well, in my view, it could entail several things. It would provide granularity in identification of customary international law. The syllabus says that the Commission could address compensation in terms that are general in scope and also sufficiently detailed in substance to reflect its importance in the law of responsibility, analogously to the 2006 articles on diplomatic protection. Address situations where the right to compensation accrues directly to any person or entity other than a state, with a great deal of recent investment and human rights law practice engaging with the ILC work, while formally speaking, as those recalling Article 33, paragraph 2 will know, falling outside the 2001 articles. I know that one of the questions identified in the syllabus is the extent, if any, that the applicable secondary rules may be affected by the character of the entity invoking responsibility, particularly certain non-state entities. And again, in the written version, certain is a word that appears in brackets. Finally, engage in line with the distinction between primary and secondary rules with the good examples of application in specialist fields. As the syllabus notes, the distinction between identification and application here replicates the approach of the recent judgments of the ICJ on compensation, which pose a legal question in terms of general principles of, or consistent with, the 2001 articles, and answer it by reference to diverse authorities that constitute the best examples in the particular field of international law. Fourthly, how might the ILC approach the topic? The syllabus suggests focus primarily on Article 36, also addressing other issues necessarily implicated by identification of rules of compensation and commonly involved with the application in practice, such as Article 31 on reparation, 38 on interest, and 39 on contribution to the injury. The topic would address compensation for breach of all primary rules, including situations where the right to compensation accrues directly to any person or entity other than a state, or where compensation arises under the law of responsibility of international organizations, although not international criminal law. And it would not address other forms of reparation or issues in parts 1 or 3 of the articles. In other words, just content of responsibility, not basis or implementation. The work of the Commission may take the form of principles, which is the preference expressed in the syllable, or articles. Finally, and this is really the final point, why this topic in this institution at this point. Let me repeat the highest possible praise for how the Commission approached reparation and compensation in the 2001 articles, guided by the stellar Special Rapporteur James Crawford, who built in turn on the work of the penultimate Special Rapporteur Gaetano Arangio Ruiz, whose sound contribution to the topic is, in my view, severely underappreciated. But those were not the central preoccupation of scholarship in the final phase of the project. As a flick through the Annuaires Français and American and European journals, if even do not go further, will suggest, and the available practice was sparse. The UK noted in the 1993 Sixth Committee that many of the authorities culled were somewhat old, and there was a legitimate question of how far the guidance they provided remained valid for the current times. And the syllabus similarly suggests that when the Commission turned to compensation in the 1990s, it could draw upon only relatively few recent reasoned awards dealing with assessment of material damage as between state and state. I spoke on how the situation in the last 25 years has changed in quantitative terms, but of more importance is the qualitative shift in the underlying balance. Historically, reparation was viewed as dividing the world neatly into the claimant and respondent states, with consensus hard to identify because law on the subject has been formed in a period characterized by an intense conflict of systems and interests, to borrow from the language from Barcelona Traction, Light and Power Company Limited. The contemporary dynamic is different. Please brace for the extended but final quote. All states may face claims regarding compensation and may invoke responsibility of other states themselves or have nationals that directly invoke it. Therefore, they would seem to have a shared interest in greater clarity in the content of applicable rules and the better instances of their application, to further peaceful settlement of international disputes before international courts and tribunals, as well as by other means in less formalized settings, where compensation claims or defenses against such claims are considered, prepared, and settled. The richness and representativeness of the body of decisions, particularly since the adoption of the 2001 articles, may permit, after a careful assessment, identification of genuinely universal rules on compensation that reflect the perspectives on the various legal systems and regions of the world. The key recent decisions have been rendered in intra-African and intra-Latin American disputes, and in other cases, Western European and other states have often been respondents, and recent rules have been particularly shaped by the contributions of African and intra-American regional institutions. The leading teachings on compensation and reparation also reflect a high degree of gender diversity. The Commission's work on international responsibility is at the core of these developments, and it is the Commission, taking into account the important contribution by courts and tribunals as well as by specialized organizations, that would be best placed to address the topic at the general and universal level. End of quote. International law is a serious discipline that addresses serious matters, but it doesn't mean that international lawyers therefore should always take themselves too seriously. Some memorable inaugural lectures have poked gentle fun at the follies of academia. I will not follow that line. In my experience, what works in Dennis Holland and Gideon Schreier lecture theaters also works in Salle Bank de Anne in Geneva and the Trusteeship Council Chamber in New York. I will leave you with 3 insights that have served me well in navigating academia as well as the international community. Everything can be done, but never for the first time. Not taking the floor is rarely a matter of regret. And nothing is ever truly settled because there's always the next year. Thank you, and I wish you good fortune for the international law to come.
Thank you, Martins. And you've set up goodness knows how many targets that you will doubtless come to hit in the years that follow. But before that, there is a ceremony to be performed by your dean.
Martins, wonderful lecture. I think we need to give Martins another round of applause. So Martins, by the powers invested in me as Dean, on behalf of the Faculty of Laws, I now formally inaugurate you as Professor of Public International Law in the Faculty of Laws at UCL.